the AG and the ambulance purchase trial, the AG refuses to recuse himself from the case. All right, let's just go quickly over to the story here, and let me just read that. We have, okay, I have a number of stories open here. Let me just quickly read that. Okay, so the Attorney General, this case has been going on for some time, and we're looking at the issue of the court suggesting to the judge of the case, suggesting to the advising the AG to recuse himself. He says, no, I won't necessarily do that. And I don't know what your thoughts are regarding this so far.
I think that the decision by the AG is motivated by early happenings where the appointor himself has not maybe cracked the whip. I remember when the saga happened for Malam Issa, and the way he said he was not going to step aside, what President Kufuor did is fresh and still in our memories. And I think this matter, the issues are the professional and the ethical side of it. It's just to protect the legal profession and uphold the legal ethics. That's why you heard some senior officials and senior experts talking him into the act of stepping aside. The GBA is silenced, and I'm yet to hear their comment on the whole discussion. The experts and the seniors call. I think the advice from the senior lecturer, professor you mentioned the other day.
A PJ?
Yes. And a sitting judge to be worried and ask you to step aside. Not the public opinion court of Kweku and myself. The sitting judge. So let's move ahead. The public opinion court, we also have our own eye we are watching. But there's also the issue of fair hearing. The AG also must be heard. And it's also the issue of exploring his rights. He has a right to stay on. He has a right to work. He's been appointed. And then we should look at the other issue of politicization. You know, the excessive politicization of the matter is also making maybe him try to, you know, protect his political stance. Then also find out to talk about the president's decision. The power lies in the president to actually decide. You know, he has a right to appoint and also, you know, remove you from office. But going forward, I think he stands the chance of still stepping aside and protecting their profession and the ethics therein. And then the GBA should find some voice and speak, as we've known them in the past. And then also, I think that the AG should consider the advice of his seniors. He can also continue with his rights anyway, awaiting fair hearing on the matter. The need to depoliticize this subject is also very important. And the president must decide, because he actually appointed him, and he can decide to ask him to maybe step aside while this matter goes on, if he thinks also that ethical is right to recuse when matters like this, because his deputy can proceed with the case. And then finally, as for the court of public opinion, that one, like if you want me to tell you mine, my mind will never change, because I think, as mentioned early on, that he should recuse himself and allow his deputy to take over, and he should clear himself of all the accusations that have been actually, because there's a voice. We're not talking about hearsay, not a word against my word. It's a voice. So my take is that I think he has refused the advice from his seniors. He has the president to contend with because he appointed him. So let's see what the president will do about the matter.
What about you?
Kweku? I think that there's a principle that when a case is in court, you don't discuss it. Fortunately for us, there's an aspect of the case which has gone for an application, and the judge has made a ruling on the application. And so once the judge has granted a ruling on that application, we can talk about the application. So without going into the substance of the case, I want to say that the trial judge made a very huge mistake in this particular case.
How so?
Kweku, when the application for mistrial was filed by lawyers for Ato Forson and lawyers for Mr. Jakpa, ordinarily, the court will request for the counsel for both parties to make oral submissions.
Okay.
Most trials, you file the motion, then the lawyer, the court will invite you for oral submissions to argue why they believe that, based on the evidence they have provided to the court, the court should grant their motion for a mistrial. Then the Attorney General or the prosecution would have then gone to say, based on the submissions and the applications filed by the petitioners, this is the basis that we believe that you cannot grant the mistrial. The trial judge did not do that. She only relied on the submission in the applications. So the application filed by the two petitioners and the response from the Attorney General, and decided to make a ruling. Now, in reading her judgment, it was very clear that the trial judge's failure to invite oral submissions from the petitioners undermined the judgment. It went a long way, to weaken the judgment that she gave. She made an important point in the judgment that the issue of mistrial is not something that is so much developed in our jurisprudence. And she believed that it is not something that is found within our laws, and so she cannot grant a mistrial. But rather, the petitioners should go to the General Legal Counsel to seek or to file a claim of misconduct against the Attorney General. Now, here is a problem. In court, rules of court exist for a particular reason. It exists, one, for fairness, to ensure that even if the court is going to convict somebody, a criminal, for a wrongdoing, the court does so in a just and upright manner. That's the rules of court. And that is why anything that undermines the processes of the court is enough grounds to throw your case away. Now, the principle of mistrial is an international legal principle. Just like common law principles which judges incorporate in their decision making, they are judicial precedents. Haven't you read most of our decisions from the court where the courts have resorted to decisions from English courts, from the United States of America?
Yes.
Those principles are not incorporated in our law per se, but they are international standards. And because they meet international criteria of a certain legal principle, the court will rely on those decisions to make a ruling. There are instances where even terminologies, haven't we heard people quote Black Law Dictionary in the court all the time? No, Black Law Dictionary.
I'm not familiar with that.
In the Supreme Court, election petition. Why? Is Black Law Dictionary our law?
Please wrap it up for me.
Kwaku, the point I'm making is that the judge missed a golden opportunity to write history, to set the basis for the development of mistrial in Ghana. And the judge lost that opportunity. 2, the judge made a huge mistake by ordering the Attorney General to recuse himself from the case.
Why?
Because Article 88 of the 1992 Constitution, and I'll read Article 88(1). It says, there shall be an Attorney General of Ghana who shall be a Minister of State and the principal legal advisor to the government. 2, the Attorney General shall discharge such duties of legal nature as may be referred or assigned to him by the President or imposed on him by this Constitution or any other law. 3, 88(3). This is where the crux of the matter is. The Attorney General shall be responsible for the initiation and conduct of all prosecutions of criminal offenses. Underline the initiation and conduct of all. So even other state institutions like IOCO, the police, who initiate prosecutions, they draw those powers from the office of the Attorney General. So they use these quasi, or they draw this quasi prosecutorial power from the Attorney General.
Yeah, but so isn't that more reason why the judge would say recuse yourself?
No, the judge cannot order him to recuse himself. The Attorney General...
You can't order, but you can advise him to recuse himself, so that, because he's such an influential, person in the mix.
But even if he recuse himself,
yes,
he's still in charge of the case by virtue of being Attorney General.
His office is, yes.
He himself. That it didn't say that after.
I hope you will still make time for the historic visit.
Koku, I'm reading the law.
Wrapping him up, yes.
The law didn't say the Attorney General's office. It says the Attorney General. It didn't say the Attorney General's office. The Attorney General shall be responsible.
Is an office.
Oh no,
it's an institution.
No, the Attorney General is a person. The Attorney General is a person.
In Supreme Court.
Article 81. There shall be an Attorney General of Ghana who shall be a Minister of State. Is the office a minister?
Fair enough. Go ahead.
So, the Attorney General is a person with prosecutorial powers. Now, these powers is responsible for all prosecutions. Even if you ask the Attorney General to step aside, he will be conducting the case from behind. All the lawyers, the state attorneys who go to court on the orders, on the powers of the Attorney General, not on their own accord. And so this is where the conflict of the judgment of the court is. It's in one instance, the court admitted the evidence, the recording, on the basis that the court claims it cannot order for a mistrial, admitted into evidence. And on one hand, the court advises the Attorney General, say that based on this evidence that we have admitted, there seem to be, in several cases, it's preponderance of probabilities. There seem to be a certain level of preponderance of probabilities that this incident might have happened. And if it happens, it prejudices your case.
Yeah.
So step aside.
Yeah.
But all this put together cannot be grounds to say this case has not been conducted in a fair and just and proper manner, and so I'm ordering for a mistrial. Clearly there was a conflict there, and the judgment of the court was contradictory, in my opinion.
All right.